Chapter 10 of Charles Sumner, the Scholar in Politics, by Archibald Grimké. This LibriVox recording is in the public domain. Struggling for the floor. In the Senate and in the House also every movement of the Friends of Freedom was met and opposed by the intolerant spirit and obstructive tactics of the Friends of Slavery. It was exceedingly difficult to obtain the floor in either branch of Congress for the introduction of matter in the interest of liberty, while in all measures pertaining to slavery it was quite the reverse. Slavery had the right of way every day and every hour during the continuance of the sessions of the two branches of the national legislature, and freedom had to stand aside or get ground under the juggernaut wheels of its arrogant adversary. Here is a senatorial instance of just this sort of thing, included by Mr. Sumner in the edition of his works, and reproduced by him from the Congressional Globe. The day is July 31, 1854, and the occasion the report of the Committee on Pensions, through Mr. Seward, of a bill for the relief of the aged widow of a soldier of the War of 1812, who had died of wounds received therein. The moment the measure was introduced, a Southern senator moved an amendment granting a pension to the widow of the man who was killed in the attempted rescue of Anthony Burns from the courthouse in Boston on the evening of the 26th of the previous May, as the reader will doubtless recall. Being clearly in the interest of slavery, and notwithstanding objections thereto, the amendment was adopted. Thereupon Mr. Sumner moved an amendment repealing the Fugitive Slave Act, which was, of course, promptly ruled out of order as not germane to the bill under consideration. The bill for the relief of the widow of a hero of the War of 1812, together with the amendment for the relief of the widow of a volunteer hireling in the execution of the Fugitive Slave Law, were put upon their passage. At this stage of the business Mr. Sumner springs to his feet, when ensues the following struggle between him, aided by friends, and the slave power. Mr. Sumner: In pursuance of notice, I now ask leave to introduce a bill. Mr. Stewart of Michigan: I object to it, and move to take up the River and Harbor Bill. The presiding officer: Mr. Cooper of Pennsylvania: The other bill is not disposed of. The third reading of a bill for the relief of Betsy Nash. The bill was then read a third time and passed. Mr. Sumner: In pursuance of notice, I ask leave to introduce a bill, which I now send to the table. Mr. Stewart: Is that in order? Mr. Sumner: Why not? Mr. Benjamin of Louisiana: There is a pending motion of the senator from Michigan to take up the River and Harbor Bill. The presiding officer: That motion was not entertained because the senator from Massachusetts had and has the floor. Mr. Stewart: I make the motion now. The presiding officer: The chair thinks it is in order to give the notice. Mr. Sumner: Notice has been given, and I now, in pursuance of notice, introduce the bill. The question is on its first reading. The presiding officer: The first reading of a bill. Mr. Norris of New Hampshire: I rise to a question of order. Mr. Sumner: I believe that I have the floor. Mr. Norris: But I rise to a question of order. I submit that that is not the question. The senator from Massachusetts has given notice that he would ask leave to introduce a bill. He now asks that leave. If there is objection, the question must be decided by the Senate whether he shall have leave or not. Objection is made, and the bill cannot be read. Mr. Sumner: Very well. The first question, then, is on granting leave, and the title of the bill will be read. The presiding officer to the secretary: Read the title. The secretary read it as follows: A bill to repeal the act of Congress approved September 18, 1850, for the surrender of fugitives from service or labor. The presiding officer: the question is on granting leave to introduce the bill. Mr. Sumner: and I have the floor. The presiding officer: the senator from Massachusetts is entitled to the floor. Mr. Sumner: I shall not occupy much time, nor shall I debate the bill. Some time ago, Mr. President, after the presentation of the memorial from Boston, signed by 2,900 citizens without distinction of party, I gave notice that I should at a day thereafter ask leave to introduce a bill for the repeal of the Fugitive Slave Act. Desirous, however, not to proceed prematurely, I awaited the action of the Committee on the Judiciary, to which the memorial and others of a similar character were referred. At length an adverse report was made and accepted by the Senate. From the time of that report down to this moment, I have sought an opportunity to introduce this bill. Now at last I have it. At a former session, sir, in introducing a similar proposition, I considered it at length in an argument which I fearlessly assert. Mr. Gwin of California: I rise to a point of order. Has the senator right to debate the question or say anything on it until leave be granted? The presiding officer: my impression is that the question is not debatable. Mr. Sumner: I propose simply to explain my bill, to make a statement, not an argument. Mr. Gwin: I make the point of order. The presiding officer: I'm not aware precisely what the rule of order on the subject is, but I have the impression that the senator cannot debate. Mr. Sumner: the distinction is this. Mr. Gwin: I insist upon the application of the decision of the chair. Mr. Mason of Virginia: Mr. President, there is one rule of order that is undoubted, that when the chair is stating a question of order, he must not be interrupted by a senator. There is no question about that rule of order. The presiding officer: the senator did not interrupt the chair. Mr. Sumner: the chair does me justice in response to the injustice of the senator from Virginia. The presiding officer: order, order. Mr. Mason: the senator is doing that very thing at this moment. I'm endeavoring to sustain the authority of the chair, which certainly has been violated. The presiding officer: it is the opinion of the chair that the debate is out of order. I'm not precisely informed of what the rule is, but such is my clear impression. Mr. Walker of Wisconsin: if the senator from Massachusetts will allow me, I will say a word here. Mr. Sumner: certainly. Mr. Walker: it is usual, upon notice being given of intention, to ask leave to introduce a bill. The bill is sent to the chair, and it is taken as a matter of course that the senator asking it has leave. But in this instance, differing from the usual practice, objection has been made to leave being granted. The necessity is imposed then of taking the sense of the Senate on granting leave to the senator to introduce his bill. That then becomes the question. The question for the chair to put is, shall the senator have leave? The presiding officer: that was the question proposed. Mr. Walker: now, sir, it does seem to me that it is proper and that it is in order for the senator to address himself to the Senate with a view of showing the propriety of granting the leave asked for. He has a right to show that there would be propriety on the part of the Senate in granting the leave. I think, therefore, as this may become a precedent in future in regard to other matters, that it should be settled with some degree of deliberation. Mr. Gwin: let the chair decide the question. The presiding officer: the chair has decided that debate was not in order in his opinion. Mr. Sumner: from that decision of the chair, I most respectfully take an appeal. The presiding officer: from that ruling of the chair, an appeal is taken by the senator from Massachusetts. The question is on the appeal. Mr. Benjamin: in order to put a stop to the whole debate, I move to lay the appeal on the table. That is a motion which is not debatable. Mr. Sumner, is that motion in order? The presiding officer: Certainly it is in order. Mr. Weller of California: I desire to make one remark in regard to the rule. The presiding officer: It is not in order now. The question must be taken without debate. Mr. Sumner: Allow me to state the case as it seems to me. I was on the floor and yielded it to the senator from Wisconsin strictly for the purpose of an explanation. When finished, I was in possession of the floor, and then it was that the senator from Louisiana on my right, the presiding officer: Will the senator from Massachusetts give leave to the chair to explain? Mr. Sumner: Certainly. The presiding officer: A point of order was made by the senator from California, Mr. Gwin. That debate was not in order upon the question of granting leave, and the chair so decided. The senator from Massachusetts then lost the floor, as I apprehend, and he certainly did by following it up by an appeal. After that he could go no further. He lost the floor then again for a second time, and then it was that the senator from Louisiana intervened with another motion, which is certainly in order, to lay the appeal on the table. That is not debatable. This, it seems to me, is the state of the case. Mr. Chase of Ohio: Will the chair allow me to make a single statement? The presiding officer: Certainly. Mr. Chase: The senator from Massachusetts rose and held the floor during the suggestion made to the chair by the senator from Wisconsin. The chair then, after the senator from Wisconsin had finished his suggestion, declared his opinion to be, notwithstanding the suggestion, that debate was not in order. The senator from Massachusetts then took an appeal and retained the floor for the purpose of addressing the Senate on that appeal. While he occupied the floor, the senator from Louisiana rose and moved to lay the appeal upon the table. That will be borne out by the gentlemen present. The presiding officer: That is so, but the chair does not understand that debate was in order on the appeal. The appeal was to be decided without debate, and therefore the senator from Massachusetts necessarily lost the floor after he took his appeal. Mr. Bell of Tennessee: I would inquire whether there is not a bill already pending for the repeal of the fugitive slave law. The presiding officer: I have not inquired of the secretary, but it is my belief there is a similar bill pending, but it was not on that ground the chair made this ruling. Mr. Bell: I would inquire whether there is not such a bill pending. Did not the honorable senator from Ohio some time ago bring in such a bill? Mr. Weller: I think he did. Mr. Chase: No, sir. Mr. Bell: Then I am mistaken. Mr. Chase: My bill is not on that subject. The presiding officer: The question is on the motion of the senator from Louisiana to lay on the table the appeal taken by the senator from Massachusetts from the decision of the chair. Mr. Chase: I ask if the motion of the senator from Louisiana is in order when the senator from Massachusetts retained the floor for the purpose of debating the appeal. Mr. Benjamin: The senator is not in order in renewing that question which has already been decided by the chair. The presiding officer: If the chair acted under an erroneous impression in supposing that debate on the appeal was not in order when it actually is, it was the fault of the chair, and it would not have been in order for the senator from Louisiana to make the motion which he did make while the senator from Massachusetts was on the floor. But the chair recognized the senator from Louisiana, supposing that the senator from Massachusetts had yielded the floor. The senator had taken appeal. He followed it up by no address to the chair, indicating an intention that he intended to debate the appeal, or the chair certainly should so far have recognized him. But the chair would reconsider his ruling in that respect with the consent of the senator from Louisiana. Mr. Bright of Indiana, the chair will permit me to suggest that I think the motion proper to be entertained now is the one proposed by the senator from New Hampshire, Mr. Norris. The senator from Massachusetts presented his bill. The senator from New Hampshire raised the question as to whether the Senate would grant leave to introduce it, and I think the proper question to be put now is, will the Senate grant leave to introduce a bill repealing the fugitive slave law? The effect of the motion of the senator from Louisiana would be to lay the subject on the table, from which it might be taken at any time for action. For one, I desire to give a decisive vote now, declaring that I am unwilling to legislate upon the subject, that I am satisfied with the law as it reads, and that I will not aid the senator from Massachusetts or any senator in the presiding officer. The senator from Indiana is certainly not in order. Mr. Bright, I certainly am in order in calling the attention of the chair to the fact that the senator from New Hampshire, the presiding officer, the senator from Indiana, is not in order. Mr. Bright, then I will sit down and ask the chair to state wherein I am out of order. The presiding officer, in discussing a question which is not before the Senate. Mr. Bright, I claim that the motion is before the Senate. The senator from New Hampshire raised the question immediately that the presiding officer, the chair, decides otherwise. Mr. Bright, then I appeal from the decision of the chair, and I state this as my point of order, that before the bill was presented in legal parlance, the senator from New Hampshire raised the question as to whether the Senate would grant leave, and that is the point now before the Senate. The presiding officer, the chair, will state the question which he supposes to be pending. The senator from California made a point of order that debate on the bill proposed to be introduced by the senator from Massachusetts was not in order. The chair so ruled. From that ruling, the senator from Massachusetts took an appeal. The chair supposed that the senator from Massachusetts had yielded the floor, and he gave the floor to the senator from Louisiana, who moved to lay that appeal on the table. That is the question which is now pending. The chair before suggested that if the senator from Massachusetts had not yielded the floor, he had made a mistake in giving the floor to the senator from Louisiana. But he did not suppose that the senator from Massachusetts, after taking the appeal, without some indication of his intention to debate it, continued to hold the floor, and he therefore recognized the senator from Louisiana. The chair is sorry if he did the senator from Massachusetts injustice in that respect, but he did not hear him and recognized the senator from Louisiana. Mr. Bright, I would respectfully ask the chair what has become of the motion submitted by the senator from New Hampshire. The presiding officer, the chair, did not understand him to submit a motion, but the senator from California took his point of order. Mr. Bright, I wish to inquire of the senator from New Hampshire whether he has withdrawn his motion. The presiding officer, it was not entertained. It is not in his power to say whether it was withdrawn or not, for it was not entertained. Mr. Norris, I think I can inform my friend from Indiana how the matter stands. The senator from Massachusetts proposed to introduce a bill on notice given. I raised the question that it could not be introduced without leave of the Senate if there was objection. Mr. Sumner, do I understand the senator to say without notice given? I ask leave to introduce the bill in pursuance of notice. Mr. Norris, the senator from Massachusetts, I have already stated, offered his bill agreeably to previous notice. Mr. Sumner, precisely. Mr. Norris, the question was then raised whether it would be received. If there was objection, the question arose whether leave should be granted to the senator from Massachusetts to introduce the bill. Mr. Sumner, that is the first question. Mr. Norris, the senator from Massachusetts, upon the question of granting leave, undertook to address the Senate. He was then called to order by my friend from California for discussing that question. The chair sustained the objection of the senator from California. From the decision of the chair, the senator from Massachusetts took an appeal, and that is where the question now stands, unless the senator from Louisiana had a right to make the motion which he did make, which was to lay the appeal on the table. The presiding officer, the question is, unless the senator from Louisiana will disembarrass the chair by withdrawing it, on the motion of the senator from Louisiana to lay the appeal on the table. Mr. Sumner: On that motion I asked for the yeas and nays. The yeas and nays were ordered. Mr. Foote of Vermont: On what motion have the yeas and nays been ordered? The presiding officer: On the motion of the senator from Louisiana. Mr. Walker: I wish to know, before voting, what will be the effect of a vote given in the affirmative on this motion. Will it carry the bill and the whole subject on the table? Mr. Foote: An affirmative carries the whole measure on the table. The presiding officer: If the motion to lay on the table be agreed to, it carries the bill with it. Several senators: No, no. Mr. Benjamin: The question is whether on the motion for leave to introduce the bill there shall be debate. The chair has decided that there shall be no debate. Those who vote yea on my motion to lay the appeal of the senator from Massachusetts on the table will vote that there is to be no debate upon the permission to offer the bill, and then the question will be taken upon granting leave. Mr. Walker: The chair decides differently. The chair decides, if I understand, that it will carry the bill on the table. Then how can we ever reach the question of leave when objection is made? Mr. Weller: I object to this discussion. The chair will decide that question when it arrives. It does not arise now. I insist that the secretary shall go on and call the roll. Mr. Walker: Suppose some of us object to it. Mr. Weller: Then I object to your discussing it. The presiding officer: The chair, on reflection, thinks that the motion, if agreed to, would not have a further effect than to bring up the question granting leave. Mr. Bright: I desire to understand the chair. I do not wish to insist on anything that is not right, or that is not within the rules. That I insist upon having. The honorable senator from Louisiana is right in his conclusions as to his motion, provided he had a right to make the motion, but I doubt whether he had a right to make that motion while the motion of the honorable senator from New Hampshire was pending. I do not wish, however, to consume the time of the Senate. If the effect of the decision of the chair is to bring us back to the question as to whether we shall receive the bill or not, I will yield the floor. The presiding officer: That is it. Mr. Bright: Very well. Mr. Sumner, before the vote is taken, allow me to read a few words from the Rules and Orders and from Jefferson's Manual. 1 day's notice at least shall be given of an intended motion for leave to bring in a bill. That is the 25th rule of the Senate, and then to that rule, in the publication which I now hold in my hand, is appended from Jefferson's Manual the following decisive language: When a member desires to bring in a bill on any subjects, he states to the House in general terms the causes for doing it, and concludes by moving for leave to bring in a bill entitled, etc. Leave being given on the question, a committee is appointed to prepare and bring in the bill. Now I would simply observe that my purpose was merely to make a statement. Mr. Benjamin: I call to order. The presiding officer: The senator had presented his bill and was debating it afterwards. The question is on the motion of the senator from Louisiana to lay the appeal on the table, and on that the yeas and nays have been ordered. The appeal was ordered to lie on the table by a vote of 35 to 10. The Senate then proceeded to record its refusal to grant leave to introduce the bill by a like vote of 10 to 35. Thus ended this hour's struggle for the floor on the part of Mr. Sumner with the slave power, which was seconded at every point, the reader doubtless observed, by Northern representatives eager to do its service. End of chapter 10.